In fact, the last time we appeared in court, we were directed to file our application, in which application we were seeking the stay of the magistrate court proceedings because an identical matter discussing the same issues is being held at the High Court. At the High Court, the accused persons have challenged the very gazetting of the farm, saying it is not in accordance to Section 72. The prosecution in our argument wants to presuppose or to presume that the High Court is going to rule against us, and therefore we should be evicted. So I say that should not be done. They should wait the outcome of a superior court that is seized with the same question. Secondly, we were arguing that the High Court and the Supreme Court have ruled that pending the determination of the matter by the High Court as to whether the gazetting was lawful or unlawful, the accused persons must be in possession of the farm. They must be restored into the farm. So proceeding with this matter at the magistrate court would be undermining the order of the High Court, which has been confirmed by the Supreme Court. We made those arguments. The magistrate court argues that no, these are two separate processes. They are still free to proceed to have the accused answer to the charges of unlawful occupation, despite the fact that there are orders of the High Court and Supreme Court saying they must be in occupation. Right. We then applied to say we would want to take that decision on review, and the position of the magistrate was that no, we will still proceed with the trial whilst we make that application for review. We adjourned and we're supposed to resume at 2:15, which we did. We filed an answer to the charge and accepted to the charge on the grounds that in fact it does not disclose any offense. For there to be an offense, the law is quite clear. You must give the occupiers who have remained in occupation 3 months' notice. There is no notice that was ever given, and therefore to that extent, that charge does not make the allegation that they were given any notice. In fact, as a matter of fact, it was not given. We are saying procedurally, they can't charge the accused on offense that has not been perfected. But when we filed our exception, or when we made that application, the state said it was not ready to answer. In fact, it failed to download the law that we had referred to. As a consequence of that, the matter has been referred for us to make written submissions or to file our written application. They file their answer to that. We file our heads of arguments, and then we come back on the 25th of October to motivate and maybe quite possibly whether he wants to give an extempo judgment on the day in question, we will see. That is what has happened today.